Hi guys, it's Kathy. We made it to Friday. Yes, sir. Barely made it to Friday, but we made it. Alright, got a trial for you. This guy was naughty in jail. Although, this guy says he was not naughty in jail. Let's see what the jury thinks. It's a jury trial, and it's just today. It'll be over today.
Was it me on the screen? They took 11 months to have a dude to go in there after asking, looking at what hindrance is. They had somebody to play that out. That's what happened. And that wasn't me.
Oh. It's a little bit short for me.
So I just skipped jury selection and instructions. We're right into opening statements.
That's either one. You good?
You just have to talk into a microphone.
Yes, Judge. I think we're going to get the stand microphone.
Okay. Just Mr. Elliott, please remember to speak into the microphone and be loud.
All right. Good afternoon again, y'all. Again, my name is James Elliott. I'm the prosecutor in this case. We're here today, Mr.
You guys are going to hear some stellar opening statements. Really stellar.
Mr. Jones is charged with obstructing or hindering a law enforcement officer. Facts of this case are pretty straightforward as I see them. I think you will as well. Mr. Jones was incarcerated in the Hall County Jail. He was instructed to return back to his cell, and he refused several instructions to return back to his cell. Ultimately, he wound up being escorted back to his cell. Out of that, I don't think that the case is much more complicated than that. Then I think, as you see the evidence, hear the testimony from Officer Young and Deputy Davidson, that you'll understand Mr. Jones failed to comply with those instructions and violated the law. Thank you very much.
Ms. Lockwood Sims.
Yes, Your Honor.
You may proceed.
Good afternoon. Again, my name is Donald Lockwood Sims, and I'm representing Mr. Jones in this case. So again, Mr. Jones is charged with obstruction or hindering law enforcement in the lawful duties when they were giving him commands. He was incarcerated in the Hall County Jail at the time this incident happened. Everyone has the utmost respect for law enforcement, and we know how complicated their job is. You give them respect and you try and follow every command that they are giving you. However, as you get older, you don't hear as well, you don't see as well. And when you have multiple officers giving you multiple instructions, sometimes it's difficult to be able to decipher exactly what it is they're asking you to do. So obviously we're just asking that you give your undivided attention to all of the information that's presented before.
Go to your cell. That's very difficult to understand. I get it. I understand.
For you. And then at the conclusion of the case, and we're asking that you will render your decision according to what you have observed and what you have seen. Thank you.
All right. Thank you, Ms. Lockwood Sims. All right. Are we ready to proceed with the state's first witness?
Yes, Your Honor. We call Officer Young to the stand.
And you invoke the rule of sequestration? Yes, okay. So Deputy Young is the first witness. So any other witnesses or anybody else who expects to be a witness in the trial of this case, if you'll remain in the hallway till called. All right, if you'll raise your right hand, do you swear or affirm the testimony you shall give in the matter now pending before the court, the state of Georgia versus Jermaine Jones, will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated. If you would, make yourself as comfortable as you can and speak directly into the microphone. You may proceed, Mr. Elliott.
All right, Mr. Young, if you'll forgive me, would you state your full name for the record?
Tyler Young.
Tyler Young. All right, Mr. Young, are you sorry, you're wearing a Hall County Sheriff's Office uniform. Are you still employed at the Hall County Sheriff's Office?
Yes, sir.
All right. What's your role with them? Are you an officer or a deputy?
I'm an officer.
Officer, all right. How long have you been employed with the Hall County Sheriff's Office?
3 years.
3 years. And were you employed with the Hall County Sheriff's Office on April 26th, 2025?
Yes, sir.
All right.
I did not speed this up, by the way. Yes, opening statements were fast. I don't get it. It's like they didn't put any effort in it at all. They are speaking so fast for Georgia. I'm shocked and amazed.
On that date, were you working in the Hall County Jail?
Yes, sir.
All right. And on that date, were you a certified jailer?
Yes, sir.
How did you become a certified jailer?
I attended jail school.
All right. How long was that?
2
Great
weeks.
type.
All right.
Yeah.
What did they teach you in jail school, just generally? Is it?
We covered a lot of topics: the inmate rights, de-escalation, use of force.
All right. On April 26, 2025, we discussed you were working in the Hall County Jail. Do you recall an incident that day?
Yes, sir.
All right. Do you recall who that incident was with?
Yes, sir.
Who was that
It
incident
was
with?
Mr. Jones.
All right. Do you see Mr. Jones here in the courtroom today?
Yes, sir.
All right. Could you identify him, pick him out maybe by an article of clothing that he's wearing today?
Yes, sir. He's the individual sitting in the center wearing the black shirt.
All right. And if the record will reflect that Officer Young is pointed to the defendant, Your Honor.
The record will reflect he's identified the defendant.
Maybe jail school is in the same building that they give college degrees for personal trainers. Maybe. I don't know.
Mr. Jones.
Do you recall what led up to the incident with Mr. Jones?
Yes, sir, I do.
All right. Would you care to briefly describe that?
Yes, sir. We were doing a morning rotation at that time. I noticed Mr. Jones had a piece of cardboard in his hand. I asked him to give it up. He was heading down the steps anyway, so I just told him to give it to Officer Samuels, who was at the bottom down there. And then Inmate Jones didn't want to give up the piece of cardboard, and when he did give it up, Officer Samuels and him began to scuffle, and I responded.
All right. When you say that Mr. Jones gave up the piece of paper, did he hand it to Officer Samuels?
No, sir. If I remember correctly, he ripped it up and threw it on the table and told Officer Samuels to pick that crap up or something to that effect.
Okay. And was Mr. Jones instructed to return back to his cell?
Yes, sir. Officer Samuels told him to go back to his room at that time.
Did Mr. Jones return to his cell?
No, sir.
All right. Were you wearing a uniform on April 25th, 2025?
Yes, sir.
All right. As part of that uniform, do you wear a body-worn camera?
Yes, sir.
Is that part of your daily uniform? You wear it every day?
Yes, sir.
All right. Was it on and recording that day?
Yes, sir.
Have you had an opportunity to review that video before you appeared today, or before you came in today?
Yes, sir.
All right. And that video you saw, that's a true and correct video of what happened. You don't see any material alterations or deletions to it?
Correct.
All right. And, Your Honor, I'm going to, I guess we have a video coming up. Ms. Lockwood Sims, it's going to be video, I'm sorry. For reference, it's going to be axon_body_2025-04-2026_0910.mp4.
The name of the video is longer than his opening statement.
And for identification purposes, this is going to be State's Exhibit 1,
This will be State's Exhibit 1, Your Honor.
and you're tendering it?
I'm tendering it.
Any objection?
No objection, Your Honor.
It's admitted, and you may publish it throughout your direct.
Thank you, Your Honor. We
Is that where you want to start it? Okay. So just come back where you're starting it.
All right. And we're going to start this video at 8 minutes and 35 seconds into the video, Your Honor.
Any objection, Ms. Lockwood Sims?
Well, I'm not really sure where they're starting the video, Your Honor. We would just ask at some point that they play the video in its entirety. I'm not sure exactly where 835 is on the video.
No, you can play your part if you want to. You can't tell the prosecutor how to give their case. I am sick of these people. I am sick of these lawyers. They need to go to lawyer school, which is right next to jail school.
There's like 6 minutes and 44 seconds left, so it's a little over half. Does she want the whole thing?
That's about where Mr. Jones leaves his cell right here. Before that, they were walking through, it's before it goes on the steps.
No objection.
Okay, it's admitted and you may publish.
Call of Duty?
And we're starting the video at 8 minutes and 35 seconds.
Come on, Mr. Jones. Thank you. What's that? Well, you can't have that. Yeah, but you can't have that. That's as far as I'm concerned, that's trash. Well, you can't have cardboard. You can't have that. I don't even know how you got that. Well, give that to Officer Samuels. Well, you can't have that. That's fine. You still can't have that. Thank you.
Jones, turn around. Put your hands back.
Give me your hand. Give me your hand. Stop. Stop.
I got close.
Get my pencil, man.
Don't move.
Get my pencil. What the fuck?
You got it?
Got one.
He's in cuffs.
Quit moving, Jones. Quit moving.
Stop moving. I'm gonna tase you again.
Damn right.
Got it on him? Good.
Hold on. This isn't good.
Your Honor, we're stopping at 11 minutes and 2 seconds into the video. All right. Officer Young, is that an accurate depiction of the events that happened on the 26th of
Yes, sir.
last year? All right. You instructed Mr. Jones that he wasn't allowed to have that cardboard because it was trash?
Yes, sir.
All right. Are inmates allowed to have trash with them?
No, sir.
All right. But ultimately, the issue that arose out of this was Mr. Jones failed to comply with an instruction to return to his cell. Is that
Yes, sir.
correct? Are inmates required to return to their cells when they're instructed to do so?
Yes, sir.
All right. In your opinion, is that a lawful command?
Yes, sir.
All right.
I would like to know what he was saying. Does he recall what he is saying? Does this cause a safety issue? How does it cause a safety issue? Why are you not allowed to have track?
Is this a lawyer in training? Do you think he's training? I don't know.
Do you recall what Mr. Jones was saying in the video?
I believe he was asking why he couldn't have it.
All right. And you instructed him that it was trash, is
Yes,
that
sir.
correct? Was cardboard trash, or I guess cardboard is classified as trash, is that they're not allowed to have it because it's a safety hazard or something?
Yes, sir. Cardboard's not something we give the inmates just because it could be used as handles for weapons later on down the road. I'm not even sure how he got the cardboard. I just noticed it, and I just knew it wasn't something he could have.
Okay.
Dear lawyer, if this guy isn't going to listen to people who are going to tase him for having cardboard, there is no way you're going to be able to control this man.
All right, last little bit here. The jury saw Mr. Young be taken, sorry, I apologize, saw Mr. Jones be taken to the ground on there. Is that standard procedure when inmates don't comply?
Yes, sir.
All right. What determines the amount of force that is used in those situations?
It's the force that would be reasonable.
All right, and that's a broad word, but what does reasonable force mean to you in that situation? You're the one applying the force.
Reasonable just means that, in this case, the level of aggression he was giving us, we can't necessarily, go above that.
Okay. So the amount of force necessary to
Yes,
keep
sir.
his compliance?
Yes, sir.
Okay. Do you believe the force that was used was necessary in that
Yes, sir.
situation? All right. Did that force actually gain his compliance?
Yes, sir.
All right. Was that force necessary to protect yourself and the other officers in the unit?
Yes, sir.
All right. So, Mr. Jones just saying, or not giving the cardboard over, he's not being very aggressive in that situation, is he?
No, sir, not that moment.
All right. Did he, after throwing the cardboard on the table, say anything and exhibit it?
That would ruin my job, Michael. If I couldn't carry cardboard, I couldn't right well work for food and make money.
Any signs of aggression that you saw?
Yes, sir. He said something to Officer Samuels. I think he told him to pick that shit up.
All right. Actually, I think that's all the questions we have, Your Honor.
Thank you.
Cross-examination, Ms. Lockwood Sims?
Yes, Your Honor, thank you.
Yes, ma'am.
Good afternoon, Deputy Young. How are you?
I'm doing good. How are you?
I'm doing well. I can't complain. So I just have a few questions for you, a few follow-up questions. As you know, I represent Mr. Jones in this case. So we've been trying to wrap our mind around what actually took place and what we were able to gather from the video versus what he has indicated to us. So I just have a few questions for you. Originally, he was given commands by Officer Samuels when he was coming out of his cell. Is that correct?
I was the one giving him the instructions. Him and Samuels exchange words once he gets downstairs.
Okay. So you were actually upstairs with him
Yes, ma'am.
Initially. So you were there when he came out of the cell?
Yes, ma'am.
And he began to have the interaction with you in reference to the cardboard that
Yes,
he was carrying in his hand. So initially you asked him what did he have in his hand, correct?
Yes, ma'am.
And he indicated to you that it was cardboard.
Yes, ma'am. He said it was something he used to ride on and to work out with.
And did he also tell you where he had gotten it from?
No, ma'am.
No, okay. Is that the first time that you had seen that type of cardboard?
Yes, ma'am.
So are you familiar with the fact that he has that cardboard with him all the time in the cell?
First time I had seen it.
So if he told you that he got the cardboard from the store there in the jail, would you agree with that or disagree with that?
I would have no way to confirm that.
Okay. So you have no idea where the cardboard came from other than what he
Yes, ma'am.
indicated to you? And isn't it also true that you initially told him that he couldn't have it, and he was complying with you? He pretty much just said, okay, something along those lines, correct? And then he said you told him to
Yes, ma'am. I
this
told
part
him,
of it, I guess.
told him he couldn't have it. He was speaking to me, couldn't really hear what he was telling me. But at that time, he was heading downstairs, so I just told him to give it to Officer Samuels.
At any point in time, did you hear him tell you that he would just tear it up?
I believe he said he was going to rip it up. It was kind of hard to hear because he was heading down the stairs.
At any point in time, you didn't tell him not to rip it up. You just told him to give the cardboard to the other officers.
Yes, ma'am.
And at any point in time, did you, prior to him having the interaction with Officer Samuels downstairs, did you do anything to attempt to get the cardboard from him yourself?
No, ma'am. Just figured since Mr. Jones was heading downstairs, just be easier instead of trying to get it from him on the stairs.
And so once he came completely down the stairs and he had the interaction with Officer Samuels, did you hear either of them say anything to the other?
Yes, ma'am. At that time, I heard Officer Samuels tell Inmate Jones to take it up after Jones told Samuels to pick that shit up.
I'm sorry, tell me that again?
So Mr. Jones told Officer Samuels to pick that shit up after he ripped up the cardboard. At that time, Officer Samuels told Inmate Jones to return to his cell.
And so did he give him an opportunity to return to the cell, or he just told him and then the interaction occurred?
Yes, ma'am. He was giving him the opportunity, and I believe they were exchanging words, and at that time, Officer Samuels appeared to try to grab Inmate Jones to escort him back to his room.
So you believe Officer Samuels grabbed him to try and escort him back to his room?
Yes, ma'am.
And at that point, did a further altercation ensue between the two of them?
Yes, ma'am. It was at that time that I saw the struggle taking place, and I ran from the top to the downstairs.
And in addition to yourself coming down the stairs, were there other officers nearby that came to assist as well?
Yes, ma'am. Officer Pasquale was conducting a pill call around the horseshoe of the tower, and he saw the struggle, and he responded.
So were there any additional officers besides the three of you?
I think other officers responded after they called for additional officers to respond.
And at some point, did he eventually go back to his room, or was he taken back to his room?
He was placed in the wrap.
And what do you mean the wrap, sir?
That's a restraint device that we use at the jail.
Makes you very stretchy.
And how long was he in the restraint device?
I believe he was in there for 2 hours.
2 days.
Have nothing further, Your Honor, at this time.
Redirect.
Yes, Your Honor, just briefly. All right, Officer Jones.
Young.
At the time of this incident...
Officer Young,
Or Officer
correct?
Young, I'm sorry. Officer Young. At the time of this incident, back in April 25th, 2025, how long had you been working in the jail?
I had been at the jail, I believe, a little over 2 years at that time.
All right. How long had Mr. Jones been in that unit at the time?
Not too sure, but I believe he'd been there a couple of months.
A couple months. All right. And so over that couple months, you never saw that cardboard there?
No, ma'am. No, sir.
All right. Does the jail store, I guess, what's that called?
The commissary.
Sorry, does the commissary sell cardboard?
No, sir.
Does it sell anything that contains cardboard?
I believe I believe they can buy a notepad from there, but I don't think it has a piece of cardboard like that on it.
All right. Do you recall how many times Officer Samuels told Mr. Jones to return to his cell?
I do not.
Do you recall how many times he was told to put the to discard the cardboard?
I know I told him to just hand it to Officer Samuels, and I believe Officer Samuels told him the same thing as well.
All right. Did Mr. Jones respond as if he understood what you were asking him to do with the cardboard?
Yes, sir, I believe he understood.
All right. Do you know how many times Mr. Jones was told to return to his cell before before Officer Samuels went hands-on with him?
I know he was told at least once.
All right. And then, why was he placed into a restraint device or wrap?
Once additional officers arrived, we were trying to take Mr. Jones back to his room, and he continued to pull away. Supervisors decided at that time it would just be best to place him in the wrap.
All right. Thank you.
No problem.
Recross, Ms. Lockwood Sims.
Yes, Your Honor, just a few follow-up.
Yes, ma'am.
So in the process of trying to get Mr. Jones restrained, as you indicated, isn't it true that yourself and there were several other officers involved as well basically used force against Mr. Jones? There were some licks that were passed and things of that nature trying to restrain him.
Yes, ma'am.
And at the same time, when you were passing those licks and giving him instructions to go back to his cell, isn't it true that you guys had surrounded him and there were several officers pulling this way and that way and a few licks were passed as well, correct?
We were just trying to grab Mr. Jones' hands to be able to secure him in handcuffs.
But there were some licks that were passed in his side that we were able to see?
Yes, ma'am.
Things of that nature, correct? Okay. Nothing further, Your Honor.
I didn't understand what she said there. I do not know what she said. There were some licks. There were some lakes. There was some... What did she say there? Anybody? I can rewind it. I want to rewind it just a touch. So maybe we can figure it out. You guys can tell me. Oh, wow. I said a touch.
Did Mr. Jones respond as if he understood what you were asking him to do? Thank you.
No problem.
All right, let's see what she
Recross,
said.
Ms. Lockwood Sims.
Yes, Your Honor, just a few follow-up.
Yes, ma'am.
So in the process of trying to get Mr. Jones restrained, as you indicated, isn't it true that yourself and there were several other officers involved as well basically used force against Mr. Jones? There were some licks that were passed and things of that nature trying to restrain him.
Yes, ma'am.
Licks?
And at the same time, when you were passing those licks and giving him instructions to go back to his cell, isn't it true that you guys had surrounded him and there were several officers pulling this way and that way and a few licks were passed as well, correct?
We were just trying to grab Mr. Jones' hands to be able to secure him in handcuffs.
But there were some licks that were passed in his side that we were able to see?
Yes, ma'am.
Things of that nature, correct? Okay. Nothing further, Your Honor.
Okay, is that it for this witness?
1 second, I'm sorry.
I don't think she said hits, V, but I think you're right. I think she meant licks as hits. I think you're 100% correct. I don't know, though. I just don't.
We've talked about the wrap just a little bit, and I want to clarify a little bit. We saw in the video that you and other officers gained control over Mr. Jones while he was on the floor.
Yes, sir.
And then other officers later responded to the cell.
Yes, sir.
Pod. Did Mr. Jones continue to offer resistance?
Yes, sir.
at
He
that
continued
point?
I just haven't heard it in so many years. When I was young, I got lickings all the time. Frequently. Your father's gonna give you a licking. Your father's gonna give you a licking. But I haven't heard that in so long. Monica, thank you for the cheers.
Pull away as we were trying to walk up the steps.
Okay, so he was picked back up off the ground,
Yes, sir.
and then he was being escorted up.
Yes, sir. I believe me and Officer Samuels were trying to escort him back up the steps to his room, and he continued to pull away and resist. And at that time, Lieutenant Davidson grabbed a hold of him and then decided it was going to be best to place him in the wrap.
Okay. And he continued offering resistance the entire time?
Yes, sir.
All right, thank you.
Anything else?
No, Your Honor.
All right, you may be excused. You can step down and remain in the courtroom or go about your business. State, call your next witness. call your next witness.
Lieutenant Davidson.
Lieutenant Davidson. All right, Lieutenant Davidson, you can come on down to the witness stand, remain standing when you get into the witness stand, and I'll swear you. Raise your right hand. Do you swear or affirm the testimony you shall give in the matter now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Have a seat. All right, Mr. Elliott, you can proceed with your direct examination.
All right. Good afternoon, Lieutenant Davidson. Would you state your full name for the record? We got a court reporter taking everything down.
All right, I'm Deputy Josh Davidson. I was a lieutenant. I transferred to the School Resource Officer Division.
All right. All right. Who are you currently employed with?
Hall County Sheriff's Office.
How long have you been with the Hall County Sheriff's Office?
This August will be 17 years.
All right. On April 26, 2025, were you working with the Hall County Sheriff's Office?
I was a watch commander for A Watch for the jail division.
All right. And that jail is the Hall County Jail?
Yes, sir.
That's here in Hall County, Georgia?
That's correct.
All right. On that day, you were a certified peace officer?
Yes, sir.
All right. Do you recall on that date an incident involving Mr. Jermaine Jones?
I do. I responded from, I believe it was my office, to where the incident occurred.
All right. Do you see Mr. Jones in the courtroom here today?
I do.
Could you identify him by an article of clothing?
It's the gentleman in the black collared shirt.
If the record will reflect that Deputy Davidson's identified the defendant.
It will.
All right. You weren't present in the initial.
Not in the initial. No, sir. I responded to the incident.
As you responded, could you describe what happened as you got in there?
From what I was hearing radio traffic that an incident did take place in a specific area inside the jail. So at that point, I go from where I was, stopping what I was doing, of course. Once I get in there, I see the individual on the ground had been non-compliant. He was placed on the ground so they can attempt to control him. And at that point, I believe it was the issue of getting him up to take him to return him back to his cell. At that point, when he was brought up to his feet, he became non-compliant again, which required him to be placed against a wall and then to be taken down yet again for the non-compliance. So the original task was to put the individual inside the cell, but the non-compliance factor, it's like it wanted to continue.
All right. Was Mr. Jones placed after that in what's called a wrap?
Yes, sir.
All right, and what is a wrap?
So a wrap restraint device is a device that we use to control individuals that are going to be a physical harm to my staff, myself, or their selves. It's not used as a form of punishment. It's used to kind of restrain them, because normally once they're in handcuffs and you take the individual out of handcuffs, it prevents them from swinging towards additional violence towards staff individuals. So therefore we put them in there as a result of their current actions.
You said you left the jail as a watch commander over there and went to be a school resource officer. How long ago did you become a school resource officer?
I transferred in January of this year, so I've only been doing a school resource officer capacity for 3 months now.
All right. Prior to you becoming a school resource officer, how long were you at the jail?
I stayed in the jail for 16 years.
So at the time of the incident for this case, you'd been there for about 15 years?
Yes, sir.
All right. As a watch commander, what do your typical duties entail?
As a watch commander, my typical duties are to oversee and instruct the officers to maintain the severity and the security of the jail. The lieutenant is over 2 sergeants and approximately 17 or 18 jail officers at the time that run the shift. And we monitor to be sure that they're, doing what they're supposed to do, making sure that the inmates are taken care of, and we also monitor the body camera footage system.
After the calls went out on the radio about Mr. Jones' noncompliance, how long did it take you, would you say, to get to the pod?
Myself, it probably took me about a minute and a half from where I was.
All right. Based on what you know of the force used in that incident, would you say it was reasonable?
I do.
All right. That's all I've got for now, Your Honor.
Ms. Lockwood Sims, cross-examination.
Yes, Your Honor. Deputy Davison, how are you?
I'm well. Yourself?
I can't complain today. So I just have a few questions for you, sir, on cross-examination. You indicated that it took you about a minute and a half to get from where you were to where the incident occurred. Is that correct?
Yes, ma'am.
And once you arrived there where the incident was occurring, Mr. Jones was already on the ground. Is that correct?
Correct.
And how many other officers were there when you arrived on the scene?
If I can recall, I believe it was Officer Samuels and Officer Young, and I do believe that 1 or 2 responded with me.
And were there others already there that had responded as well?
I think there might have been, a couple. I don't know exactly who was there at the time without reviewing the footage.
But there were several other officers that were there surrounding the scene, is that correct?
I know of 2 to 3.
Okay. And at the time, Mr. Jones was completely on the ground, is that correct?
That is correct.
Okay. And were the officers there trying to get him in handcuffs or trying to restrain him, or what were they exactly what they trying to do?
I believe when I showed up, he was in handcuffs, and I believe we were trying to pick him up to help him to his feet so that we could return him to his cell.
And was he verbal at that time? Was he talking to you or
Oh, yeah.
talking to the other officers?
Yeah, he was verbal. He was screaming.
And when you say he was screaming, what?
Profanity towards the officers.
Okay. At any point in time, was he indicating what had taken place or trying to explain anything to you or to any of the other officers on scene?
Mostly once the once the individuals is placed in handcuffs, our main objective is to remove them from the initial area. So we're trying to return them to their cells so that we can shut the door and exit so there's no more issues. That was the biggest thing that we were trying to do, was trying to stand him up to his feet, take him back to his cell, remove the handcuffs, and shut the door. But that was not allowed.
And when you say it wasn't allowed, what do you mean it wasn't allowed?
It means we tried to assist him to his feet. And at that point, when you're walking upstairs in handcuffs, it's my officer's jobs to make sure that you can walk up the stairs with an officer on each arm to ensure that you don't fall. And so once we get you up to that point and you're non-compliant, turning, attempting to, if you're a known individual who spits and headbutts, which any type of altercation, anybody can be capable of such that. So when you're turning towards officers who are attempting to return you to a cell, that's when he was placed on the ground again.
And you indicated that you were there at the jail, 16 years employed there.
Correct.
So do you happen to know how long Mr. Jones had been there at the time that this incident occurred?
Specifically, no, I don't remember how long
Couple
he'd
of
been
days,
incarcerated.
couple of months, a year?
I'm sure he's been in there. I'm not understanding the question.
At the time that this happened, was Mr. Jones someone that had just came in the jail, and had been there a night or two, or had he been there for weeks or months, or how long had he been there?
Mr. Jones was, particularly, he was involved into an altercation prior to this that led him to going to the floor that he was currently housed on. He had to be housed by himself because he could not have a roommate because he would want to hurt them or fight them.
So do you know if he has any medical conditions or mental illness or anything that would
No, I'm
any type
not
of behavior or
disclosed.
anything?
I'm not personally disclosed that information because I'm more so over the security factor, not the medical.
So from the time that you arrived on the scene until he was placed in the wrap, how long would you estimate that took?
By the time I got there, we picked him up, tried to get him to his cell, which that didn't happen, so we went down. I believe it was maybe between 2 to 3 minutes before I made the decision to put him in the wrap.
No further questions, sir. Thank you.
Yes, ma'am.
Redirect.
Just a few. We mentioned reasonable force a few times. Over 15 years that you had at the jail prior to this incident, how many incidents would you say you've responded to where physical force was necessary?
I'd say quite a few. I don't know the exact number, but they happen quite often inside of a jail. So, I mean, I could tell you a number of maybe 1,000, but I don't want to lie to you.
Fair enough. At least several hundred?
Several, yes, sir.
All right. And then, was it your opinion that Mr. Jones' actions were creating a safety issue for himself?
Yes, I do believe so.
And for the deputies?
Yes, sir. I do believe at that point in time, if we were to take him out of handcuffs and try to diffuse the situation by letting him go inside of his cell, after we tried, we would have been into yet another altercation, which his cell was up on the top mezzanine area because we have got 2 stories. So it was much safer to go ahead and deploy the wrap to prevent any type of further altercation. Because if we would have walked him up the steps, put him in his cell, I could have put 3 officers and his own health in jeopardy by fighting 20 feet in the air. And so we went ahead and deployed the wrap.
When you arrived, were the officers that were in the pod at the time holding Mr. Jones down, do you recall?
I would not necessarily saying holding down, because when I got there, he was in handcuffs. So they were restraining him in a way that they were shown and trained to keep them down so they can't get back up to continue an altercation.
In the last little bit, you said Mr. Jones was cursing everybody, using profanity. Do you recall anything specific he'd said?
Not off the top of my head, most of the times I've dealt with Mr. Jones has been profane language towards the staff there. Was an ongoing thing. He was placed on after his lockdown, and due to getting into altercations with an officer, he was placed on what we called high security. That means he came out, I think it was 3 times a week for a shower, but he had to be by himself, and officers had to be present due to the known violence.
That's all I have.
Recross.
I'm sorry, sir, just one follow-up from what you just indicated. You indicated that once you arrived on the scene that your officers had him pinned down in the way that they were trained to pin him down so he couldn't get back up, correct?
Didn't have him pinned down. He was, I guess, restrained, held. He wasn't pinned down.
But he was being held down to where the way they were trained to keep him down so that he couldn't get back up at that point, correct?
Yes.
Nothing further, Your Honor.
Just last little bit to clarify the time or the timeline of events. When you arrived and Mr. Jones was held down, After that, after you'd arrived, he was picked back up in an attempt to escort him back to his cell, correct?
Correct, yeah. Once, the whole thing, when I got there, I would say that the officers knew that supervisors, myself and my other supervisors, would be en route. At that point in time, they wanted to ensure that the supervisor there will be present to, control this situation. So when I'm there and I'm the supervisor, and okay, let's get this individual up, take him to the cell. And while I'm doing it, we're talking to the individual. So we're telling this person, hey, we're going to get you up. Let's go. And at that point in time, they're still trying to be non-compliant. We're going to have to go to the ground because I'm not going to walk you upstairs if you're going to attempt to fight. That just doesn't sound right to me.
All right, and so Mr. Jones was picked up off the ground to be taken back to his cell.
Correct.
And then he continued offering resistance.
Correct.
And then
which led him to be placed into the route.
Okay. Thank you.
Yes, sir.
Okay, all right. You may be excused, Deputy Davidson. Go about your business or remain in the courtroom. Call your next witness.
Stay rest.
All right. I need to have a brief, we need to take a brief comfort break so that I can handle some matters with the lawyers. So I'm going to give the jurors about a 10-minute recess, 10 minutes.
You cannot. Just be real careful. I'll get your question.
You're doing great. All right, everybody can have a seat. Any motions? We'll talk to your lawyers first before you say anything. Make sure it's okay with them.
Now, I gotta speak about these. You said.
Yeah, but you have a lawyer who's a trained attorney, so talk to Ms. Luck.
She still ain't speaking, telling you this.
Okay, well, you're not representing yourself. You've got a lawyer, so talk to Ms. Lockwood Sims before you say anything.
And I don't think defense counsel's microphone is on, so he's not coming in.
Okay. Okay, do you have a motion, Ms. Lockwood Sims?
No, Your Honor.
Okay. All right, so I need to talk to you, Mr. Jones, about whether or not you want to testify.
Yeah, I want to testify.
Okay, I got to ask you some questions about that, okay?
Yes,
All right, so do you understand that you have a right to testify, and if you want to testify, then no one can prevent you from doing so? Do you understand?
I heard part of him speaking, and I'm going to apologize right now to the Australians because I struggled understanding him. His accent is different and thick. So even I could not. I tried so hard. So maybe we'll translate it. CJ, you can translate. Just whatever you think he's saying, that's what he said.
And you have a right to do that?
Yes, ma'am.
Okay. And it's going to sound like, Mr. Jones, I'm asking you the same question 40 different ways. I just have to do this, okay? Do you understand that no one can make or compel you to testify? Do you understand that? Nobody
Yes,
can
ma'am.
make you. Okay. You have a right not to testify if you don't want to.
Yes,
Do you understand that it is not your lawyer, but you personally are the one who makes the decision about whether or not you're going to testify? Do you understand that?
Yes, ma'am.
Okay. Do you understand that if you do not testify, then I'm going to tell the jury that they cannot hold that against you in any way? Do you understand that?
Yes, ma'am.
Okay. Do you understand that if you do testify, Mr. Jones, then Ms. Lockwood Sims or Mr. Rodden, whoever's going to question you, can ask you questions, and then the state's lawyer, the prosecutor, can ask you questions? Do you understand that?
Yes, ma'am.
Okay. Do you feel like you need any additional time to think about whether or not you want to testify?
No, ma'am.
Okay. Do you want to testify or not testify?
Testify.
Okay. All right. And Ms. Lockwood Sims and Mr. Rodden, do you believe that Mr. Jones has made that decision freely and voluntarily?
I do, Your Honor.
Okay. All right, well then that's going to make my decision as well. I'm going to find that he has decided to testify with a complete understanding of his rights and that he's made that freely and voluntarily. Other than Mr. Jones's testimony, is the state going to present any other witnesses?
No, Your Honor.
I mean, the defense going to present any other witnesses?
No, Your Honor.
Okay. All right. So what I'd like to do is, after we get through this, do the charge conference. I mean, y'all are entitled to a charge conference. Katie is working on those pretty quickly. We'll do a brief charge conference. It's only 4 o'clock. We might actually get the case to the jury today, so I'm going to keep pushing. Okay. All right. Let me ask this question from the Sheriff's Department. Do we need to go ahead and have him on the stand? Or is he, like, how would you want to handle?
Kelly, I'm not 1,000% sure. I'm 50%. I'm 100% sure. Now, never mind. This judge's name is Kelly, but her name is Kelley Robertson. Judge Robertson.
Handle that. Okay. All right. Okay. So, Mr. Jones, we're going to go ahead and let you come on up to the witness stand before I bring the jury in.
Okay. Hold on. I got it. Yeah. I got all of it.
Anything else from the Sheriff's Department that you need me to?
I don't understand his defense, V. And I don't know what he says on the stand. I know what he says later to the judge. And I don't understand his defense. There was no way that was ever going to work. What he says later was, it wasn't me. That wasn't me. So,
We good? Okay. Okay. Now, Mr. Jones has a lot of pieces of paper in his hand. Before we get too far down this road, has everybody seen whatever he's got up there?
The state has not seen what Mr. Jones has, Your Honor.
Okay. Have
We
you
haven't seen everything that he has. We've seen bits and pieces of it, but not everything.
Okay. So, Mr. Jones, the lawyers have a right to see anything you're going to try and show the jury before you try and show the jury. Why don't we...
Mr. Elliott brought that to my attention. I'm not sure if he's trying to use something to refresh his recollection, because I do understand that he can use whatever he needs to refresh
Yeah, if you're just using it to refresh your recollection, that's fine. But if there's something you want the jury to see, we got to show it to the lawyers first. Does that make sense?
Okay.
Okay, are you going to try and show something to the jury?
Yeah, I'm trying to tell you what's going on. Like on the 25th of April, 21st, 22nd, April 26th, she said she reclaimed the footage. Samuels pushed me in the door. See, they're trying to cover all that up. And that wasn't me up there. They had that reran over. Someone else did it. He pushed me in the door.
Okay, well, this is what you got to tell the jury, not me. Okay, we'll just wait and deal with it when it comes up.
And the footage, she says she received it.
Okay, well, let's go then. All right, anything else?
I will just ask, I've tried to explain to him that he can use those notes of whatever he has to refresh his memory, but he can't straight read from those notes.
I'm not reading this period.
No,
I'm just sorting it
Your
out.
Honor, so I just want to make sure that Your Honor gives him those instructions.
Right. You can refresh your recollection.
Yeah.
Okay. All right, let's bring the jurors in.
Yeah.
Thank you, Ms. Lockwood Sims.
Oh, yeah. If you want to, you can read that.
Oh, you hold on to it. Okay. Well, I'll tell you what. Close the door. Do y'all need a brief comfort break? Do y'all need a quick comfort break? We got a juror in the bathroom.
Oh, yeah.
Y'all want to just stand up and stretch your legs?
That'll work.
I'm happy for a break, Your Honor.
Okay. All right, I'll give you.
Excuse me, do you all have the footage? You have the footage, what you said on the 21st or 22nd?
This footage in reference to this particular case.
Well, at the same time, that's not me on the, on that footage. You all made another copy, another person did that in that dorm. That wasn't me. If you watch the whole footage, you will see none of that went. I was wheeled up to the front in booking.
Okay.
I didn't go back up the stairs.
Hey, Mr. Jones, the jurors are ready to come in, okay? So I'm gonna bring the jurors in,
Yeah.
and then your lawyers are gonna ask your questions. Who's gonna handle the direct? You, Ms. Lockwood Sims? Okay.
Yeah.
All right.
So can that footage be played fully? I
Hang on.
never went up the stairs.
Hang on
I
just a
was
second.
pushed up front in booking.
Just 1 minute, Mr. Jones, okay?
So it couldn't have been me. That was something they.
Hang on just a second.
They made.
The jurors can't hear what you're saying. They're still coming in. All right, everybody please be seated. All right, the next witness is going to be Mr. Jones, who's going to testify, and he's already in the witness
Could you all
stand.
read this?
Ms. Lockwood Sims, you can proceed with your direct examination, ma'am.
Mr. Jones, I'm going to ask you some questions for you to respond to the jurors so that you will have an opportunity to tell the jurors the things that it is that you want them to know. So I'm going to ask you some questions, and if you don't mind, respond to the jurors so that they will understand and comprehend what it is that you would like to share with them this afternoon. So I'm going to start by asking you to state your name, please, for the jurors.
Jermaine Wesley Jones.
Could we get him sworn in, please?
Sworn in. Sorry.
So will you raise your right hand, please? Do you swear or affirm the testimony that you are about to give should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, the truth, always. The truth, that's not the truth up on that screen. That's not me.
Okay, so lower your hand. Okay, and again, will you state your full name for the jury?
Jermaine Wesley Jones.
Okay, Mr. Jones. And back in April of 2025, there was an incident that took place at the Hall County Detention Center. Are you aware of that? Are you aware of the incident that took place on that day?
April 2025.
Yes.
Yeah, 2000, yeah.
25, yes.
Uh-huh.
Okay. And as a result of that, you were charged with obstruction, correct? Were you charged
Yes,
with obstruction?
I was charged with obstruction.
Okay. And so can you tell the jurors what took place on that day that caused you to be charged with obstruction?
On that day, I came out of the room. I was on PC, actually, in 316 cell 422. I came out, T. Young, he spoke about the, what is it? Let me see. He spoke about this same cord board that Access gives me when I receive a package. Still have it. I get it like every week or every other week.
And when you say access, sir, can you explain
Access
to the
package.
jurors what?
Access package. Let me see, I have the receipts here.
So it's access package where you would order stuff from the store within the
My
jail?
family orders it.
So your family orders packages
Yes,
from?
nothing of the states.
Okay, so it doesn't belong to the state, but your family orders packages for you.
Mm-hmm.
And then they come to you from Access or in Access Packaging?
Access package.
And so the cardboard that you have, is that some of the packaging that you've received?
This is
from
where
those
the
receipts?
saltines, like little crackers come out of.
Okay.
Yeah, they come in this.
Okay, and so that's how you have those type of things in your possession, correct?
Yes.
And is that something that you have in your possession often, or was that something you just had that day?
No, I receive them and I still have it. The store man, Jay Duquit, he gives them to me. I mean, like he doesn't take them back. I try to sometimes, and he'd be like, you know, keep it, you know.
And so other than on that particular occasion, had you ever been told before that you could not have those?
Never, never.
And
Jay Duquit gives them to me. I mean, like he never receives them back.
And after this incident happened in April, you were still at the jail for some time after that, correct?
Yes, I've been there since 16 months, 2024.
And so is those cardboard pieces that you have, is that something that you continue to receive after that?
Continue to receive that. All the while I've been here. You know, you see, these are receipts.
Okay.
Yeah.
And so in you receiving that's what this incident occurred from on that day. So you came out of your dorm and you had the cardboard in your hand, correct?
Uh-huh.
And so what did the officer tell you in reference to the cardboard?
It was like, he asked me, he said, what you gonna do with the cardboard? I was like, I write my workout on it. So thereafter, he was like, give it to Samuels. I said, okay. I said, I'll just tear it up. I told him that.
And what did he say when you told him that you would tear it up?
Nothing. I went on down the steps, and like I say, that's not the right footage of me. They put somebody in there.
So let's tell the jurors what happened. So you went on down the steps.
I went down the steps. I went to the table. I tore the paper, I tore the cardboard up, and I went up, walked around the opposite way where that person walked. That wasn't me. I walked around, I'm thinking he'll be done walked out the door, turned around and walked out the door. Like T. Young was up top. I never said anything to him, period. I never cursed. I mean, the camera is seen it. That's showing something different. Somebody else, they've done a replay trying to make it seem like it's me. It's not me. If you play that, replay that, and you will see it's not me.
So when you...
And I didn't go up no steps. They came in there and wheeled me up front, wrapped me up in a wrap, and they wheeled me up front, booking.
So, sir, prior to them wheeling you up front, when you came down, you tore the paper up. And
I tore the paper up and I went around the table. I went the opposite way that individual went. And as soon as I went that way, he went to punching.
When you say he, who started punching?
Hakeem Samuels. He went to punching at me. I turned around. I never said, I turned around, ran to the wall. I ran to the wall, did this. He started punching me from behind, hit me in my head. I just had my nose was broke when I got locked up 2000, November 5th, I got locked up 2024. 2 days later, I'm in the hospital, my nose broke in Gainesville. And, stuff just kept coming at me. They steady tried to entrap me, coming to me, trying to provoke me. I'd never done anything wrong. I try to avoid situations much as possible.
So after the officers, you indicated that the officer came at you and started punching at you.
Yeah, that's not the right footage.
Follow the story, sir. So what happened after that? Once he started punching at you, did you fight back or try?
I never fought back. Period.
So did other officers show up and? They
came afterwards after T. Young and him, they radioed him, they rushed in the door, but by that time, they had me, on the ground. What was it? They had me like, I got on he had put some handcuffs or something on me. That's what he did. He put something on me, he pushed me down, my back, T. Young, and I complied, everything what they were saying. I stood up straight. As soon as the people came in, I was standing up. I never was aggressive, period. They threw me down on the ground, but when I bust my knee, I even showed B. Postma where my knee was bust. I showed Nurse Michelle where my knee was bust. And she told me, you know, she'll see about me within medical, put in a sick call. I told also, what is it, Lieutenant J. Davidson, I told him again what was going on. Told him about my knee. That was before I got out of, what was it, cell 39 or somewhere.
So, sir, after they got you on the ground, at some point, did they put you in the wrap?
Yeah, they put me in the wrap. That's what I'm saying. Like, you're saying you tried to take me up the steps. I never went up the steps. They put the wrap on me. They pushed me out in the hall. Miss Hannah, the nurse, they were right out in the hall. Lieutenant J. Davidson. I said, I thought you were going to call the medical for me, because Hakeem Samuels had pushed me in the door like on the 21st that same week, 21st, 22nd. You said you had that clipping, and at the site you said they had sent it to you. He pushed me in the door. They tried to cover that up, and like I say, those days went by, and it got to the 25th, and that's when he initiated the incident, what I'm right here sitting on the stand for, the obstruction. He made that situation seem like it existed, it was real, and it wasn't. He made that's bogus. If you watch that fully, that's not me. And if it was me, you'll see me being wheeled up there to front. I guarantee you they can't show you wheeling me up there in the front office, up there in booking. I guarantee you that on that screen right there.
So hold on a second, Mr. Jones. So I don't have any further questions for you in reference to that particular incident, but the prosecution may have some questions for you. So just hold on and see if they have questions for you.
I understood him perfectly. I didn't have any issues. When he starts talking to the judge later on is when I struggle. I struggle to understand him.
It tells you even right here.
Hang on just a second, Mr. Jones. You gotta answer questions. You can't just talk without responding to a question, okay? Just a second. The lawyers are gonna ask you questions, maybe.
Okay.
State has no questions, Your Honor.
Okay. All right, any reason why Mr. Jones can't step down and join us lawyers? Okay. All right, you can go back to the table with your lawyers, Mr. Jones. All right, is the defense going to have any other witnesses?
No, Your Honor. Thanks for us at this time.
Okay, any rebuttal? No rebuttal.
No rebuttal.
Okay. At this time, the lawyers are entitled to a brief conference with me about the law that I'm going to give you. Given how well we're doing on time, I'd like to keep going. So I'm going to take a brief recess to talk to the lawyers about the law. So I'm going to give you all another short recess, okay?
Sure, ma'am.
Hang on just a second.
Yeah, I wanted to tell them before they went at something.
Okay.
Can I tell them?
You can't just tell them something, sir. Stop.
Before they go at?
Hang on just a second. I need to talk to your lawyers about that. All right. Oh. Okay. All right, Mr. Jones, tell your lawyers whatever it is you want them to tell the jury, but you can go ahead and sit down at the table with them, okay?
It's really. It's gonna be stuff we're gonna go sit at the table, right?
Okay. I am going to print the draft that Ms. Adams has prepared right now onto this printer. Moving very fast. All right, so I don't have your request, maybe I do. Charge in front of me. Let's start with the state's request to charge. Do you have a copy, Ms. Lockwood Sims?
Yes, ma'am.
Okay.
May I approach?
Oh, no, I've got yours. I want to make sure you've got the state's.
Yes, I have the states as well, y'all.
Okay, great. Okay, presumption of innocence, burden of proof, reasonable doubt, that all looks pattern. Any objection from the defense?
No, Your Honor.
Jury, judges of law and facts, that looks pattern. Any objection?
No, Your Honor.
Evidence looks pattern. Any objection?
No objection, no.
Okay. Stipulation, we don't have a stipulation in the case, that withdrawn?
Withdrawn.
Okay, I'm gonna take that out. Direct and circumstantial evidence, I will give. Credibility of witnesses, pattern, I will give. Expert witness, we didn't have in the case, I will not give. Prior statements. Were there any prior statements?
Just what was in the video, Your Honor. Not that it,
I don't think anybody's really, like, they're not going to compare trial testimony to any prior statement, so I'm not inclined to give that. Single witness corroboration, I'll give. Defendant's choice not to testify, I would give it, even though he did testify. I think it's important to tell the jury that he doesn't have to, so I'm going to give that. Definition of a crime, I'll give. Intent, I did put in here. Any objection? I think they probably need to be charged on intent.
No, Your Honor.
Okay. Strict liability offenses, it's not a strict liability offense, so I won't give that. Strict liability offenses is like traffic case things where you don't have to prove intent. This is a charge where the state has to prove you intended to obstruct the officer, so I'm not giving what they asked for. Okay, no presumption of criminal intent, I'll give. Venue, I'll give. Sympathy, I'll give.
That's not me on the screen.
Sentencing, I'll give. Obstruction of an officer. Okay, we're going to give this in the way that's tailored to the accusation. Because it was a correctional officer, right?
Yes.
So I will tailor that. Because
People offer me 12 days.
Hakeem Samuels was a jailer. Okay. All right. So I would intend to give it this way. I'm not sure that what Katie put in here is the most recent one. I actually think that what the state asked for is the most recent, because they've changed all these to number them. Okay, well, I'll fix this.
Have a seat. You're good.
I would plan to give this as the state asked for it. I'll change it. And then obstruction of an officer, knowledge of official status. The state must prove that the defendant knew that the alleged victim was a jailer, right?
yes.
That's how they did the other time, tried to entrap me while I was in there. Dude slammed me on the steps. Silver, Officer Silver. You know, and I did nothing. The only reason why I pled to it, because I was trying to make bond. and get out. That was it.
So here's how I would intend to charge 2.4425 states request to charge 19. The state must prove that the defendant knew that the alleged victim was a jailer. This may be shown by evidence that would cause a reasonable person to know that the alleged victim was in fact such an official. Okay. All right. Then you have an amended request to charge credibility of witnesses, which I think I have given. All right, let's move now to Ms. Lockwood Sims' request to charge. Presumption, burden, sufficiency, I'll give. Defendant's failure to testify, I'll give. Grave suspicion, I will give. And misdemeanor obstruction of an officer. I think I had it the way you have it, Ms. Lockwood Sims, which is a person, well, no. Hang on, gotta find it. Yeah, a person commits the offense of obstruction of an officer when that person knowingly and willfully obstructs or hinders a law enforcement, really, it'd be just a correctional officer, right? In the law enforcement, in the lawful discharge of his official duties. I know that's not the most recent pattern, but since I've got it in here, that way, does anybody have an objection? It's a correct statement of the law.
No.
Okay, all right, I'm just gonna give it that way. Because it is, I mean, it doesn't break it up number one, number two, but it's a correct statement of the law, and I think it's sufficient, so I'm gonna give it that way. Okay, so here is what I'm gonna give them. My preliminary instructions. You are considering the state of the case of the state of Georgia versus Jermaine Wesley Jones. Issue and plea of not guilty, presumption of innocence, burden of proof, and reasonable doubt, grave suspicion, jury, judges of law and fact, evidence generally, defendant's choice not to testify, direct and circumstantial evidence, credibility of witnesses, single witness corroboration not required, sympathy, which I'm gonna move, I don't like it there. Definition of a crime, intent, no presumption of criminal intent, venue generally, the specific charges. And I'm going to put sympathy in the verdict and concluding instructions. Okay. Any objection to any of that?
No.
Okay. All right. I'm going to print these now again. And y'all review them. Y'all need a quick break before closings? Quick comfort break?
Yes, Your Honor.
All right.
Please.
All right, let's take about 5 minutes and we'll do closings. And I'll give you these charges.
What charge? I can't be charged again. Can I have a disposition before I leave this courtroom or how, everything?
Hang on. I will answer your question when your lawyers are back in here and we're on the record, okay? Do you need a break? Do you need to go to the bathroom or anything? Okay.
I like paperwork, be able to verify. That's it.
Would it be possible to get a copy of each side? Thank you. We're good. I'm gonna let the deputies handle it. No, we're printing up here. We're cooking with grease. All right. I'm going to also take a brief comfort break. 2 minutes.
The main seat comes off.
They look pretty orderly. All right. Okay. Okay. Should we need them? All right. Does everybody have everything the way they need for closing arguments?
I think so.
Okay. Is anybody going to use any technology?
Yes.
Okay. All right.
Are they queuing up another video because it's over? Maybe they're just going to replay it for the jury in their closing.
All right, we're going to go back on the record in the state of Georgia versus Jermaine Wesley Jones. We've had a charge conference, and I've provided a copy of the written charge to both sides. I'll ask for formal objections at the time they're read, but any concerns? Okay.
No.
All right, so are both sides ready to do closing arguments? Yes?
We're ready on.
Okay. You're limited on a misdemeanor to 30 minutes, which you know. State, are you going to open and conclude or simply conclude?
Simply conclude.
All right, so Ms. Lockwood-Sims, you will get to go first. Do you want the podium, or do you have everything the way you want it?
Your Honor, I'll just use the podium.
Okay. And my bailiffs would be more than happy to assist you in getting everything the way you like it. Okay. All right, we're ready to bring in the jurors. Bring in the jurors.
Stand up.
And just as note, state your mic is not on, so if you make any objections, if you would, please turn it on.
All right, y'all can go ahead and sit. The lawyers are standing up as a sign of respect to you all, but y'all can go ahead and make yourselves comfortable. All right, everybody please be seated. All right. Members of the jury, now is the time in which the lawyers are going to be able to make closing arguments to you. The evidence in the case is now closed. And so now is time for closing arguments. Because the state has the burden of proof, they have the right to open and conclude, but I understand you, Mr. Elliott, are only going to conclude and allow Ms. Lockwood-Sims to go first. Is that correct?
Yes.
All right, Ms. Lockwood-Sims, you may proceed with Mr. Jones's closing argument.
Thank you, Your Honor. Ladies and gentlemen, again, we thank you for your time this afternoon, for dedicating your well-deserved time to this case. It means a whole lot to Mr. Jones. As you know, there's no skin off of our back, but the skin off of Mr. Jones' back. He's the one that's here facing the judge and facing you all. So we just thank you for the opportunity to present the case before you. Thank you for your attentive nature to the case and just listening. And we just ask you at this time that you turn your thoughts towards what you witnessed and what you saw and what you've heard. Here you have a young man that's in the custody of the Sheriff's Department here. he has in his possession something that he has on a daily basis. When you're in custody for quite some time, everything becomes valuable to you that's not valuable to those of us that have access to everything. So even something as simple as a pen or anything to write or anything like that. So you've heard testimony to indicate that Mr. Jones had this cardboard that he actually got from the store there where he's able to buy goods for himself, where his family sends money. The cardboard pieces came from the packaging of various things that he would receive. He would hold on to that so that he could basically use that to jot down notes and write things of that nature. He indicated that he was keeping up with his exercises and things of that nature on that cardboard. We heard him come out of his cell to go down the stairs. The officer indicated that he didn't need to have that. It was what they consider contraband. We heard Mr. Jones say, well, I'll just tear it up. As you can imagine, when you have your personal thoughts and personal things on something like that, it's not like you want anybody and everybody.
Did we hear him say that? I'll just tear it up? I did not hear him say that. But maybe they'll play it again for us.
To be able to read what you've jotted down and things of that nature. So I can imagine that Mr. Jones was ripping it up so that no one else would see what was actually written on that document. He ripped it up, put it on the table, and before he knew it, the officer was coming at him, basically trying to restrain him and telling him to go back to his dorm. Unfortunately, he didn't give him an opportunity to respond or do anything. He more or less just came at him, drug him, started punching at him, throwing him on the ground and things of that nature. And then within minutes, he's basically surrounded by other officers that are...
Why didn't she say all this during the trial? This isn't what I heard. All I heard was, it wasn't me. That's a fake video. But the way she said it, he had personal information. He wrote something on there. He didn't want anybody to see it. Now I understand why he tore it up. The way the prosecutor had it was, you can't have that. So he tore it up and said, you clean it up. I mean, she should have said that during the trial.
You could see on the video kicking, punching at him. It's hard to follow commands at that point when they're saying do this and do that, but you're receiving blows to your side and being placed in handcuffs and things of that nature. So we ask that you take all of that in consideration in determining whether or not that rises to the level of obstruction where he's actually trying to hinder an officer from being able to carry out their lawful duties. I didn't see anything in this case that would indicate that the behavior of Mr. Jones was hindering them in any type of way from being able to do what they had asked him to do. So, ladies and gentlemen, we're asking that you will just consider the evidence and take a look at the evidence that was presented to you, the video, and at the conclusion of that you would conclude and find him not guilty. Again, we thank you for your time this afternoon.
Thank you, Ms. Lockwood Sims. Mr. Elliott.
Yes, Your Honor. We can have the screen.
Well, I really thought you did. It's just showing black on my end.
Okay, now that we know what we know, we're probably going to watch the video again.
Afternoon again, ladies and gentlemen. I'm going to give you a brief closing, but I'm going to share.
I can confidently say jailhouse audio is way worse than courtroom audio. And courtroom audio is bad.
The video that we saw during testimony a little while ago, all right? So we're got everything in our heads just the way it was as it happened. I thank you for your time and your patience today, and we'll just be a few minutes longer. So,
I got 29 more minutes, sir. So I wonder what I got that's not in the trial.
I'm not sure why it's doing it with my laptop as it was with Mr. Elliott's earlier.
I mean, all I've done, Ms. Williamson, is select Lawyer L laptop. I mean, that may be something on your end. Not sure.
I don't have extended displays. I'm like,
Come on, Mr. Jones. Thank you. What's that?
Something's all right. Work at him. As well as something my family sent through.
Well, you can't have that. Yeah, but you can't have that. That's, as far as I'm concerned, that's trash. Well, you can't have cardboard. You can't have that. I don't even know how you got that. Well, give that to Officer Samuels. Well, you can't have that. That's fine. You still can't have that. Thank you.
All right, I heard both them. Okay, so he said, I'm just going to tear it up. I heard that. And then I heard him turn and swear at the officer. And then I heard the officer get him.
Keep it playing. Let it play out to the room.
I'll point up. All right, y'all, that was just a brief clip of the video on there just to give a bit of context on here.
You know that's right.
We're here on State v. Jermaine Wesley Jones today. Y'all have heard from a couple officers, Officer Young, Deputy Davidson, about what happened today. Mr. Jones is charged with obstructing or hindering an officer. There's not a whole lot to that charge. An officer gives you a lawful command. Defendant fails to comply with the lawful command, and the defendant's failure...
Mr. Jones, don't talk anymore while he's talking, okay? You understand?
Yes, ma'am.
All right, you can proceed.
And that defendant's failure to comply with the commands prevents the law enforcement officer from doing his duties. Fact.
You guys don't have sound? Do you guys not have sound all of a sudden? Because that would make sense. Jude, refresh.
Facts matter. Some of them do, some of them don't, but here are the facts that do matter. Officer Samuels, in the course of his duties, instructed Mr. Jones to return to his cell. Y'all saw that at the tail end of that video just now. Mr. Jones was told to return to his cell. He'd already put the cardboard on the table. Officer Young thanked him for putting the cardboard on the table. Then he was instructed to return back to his cell. He turned around and offered Officer Samuels some profanities and turned around, fronted up to Officer Samuels. You see it in the video. And then at that point, Mr. Jones is restrained. We talked a little bit further on with Officer Young and Officer Davidson, or Deputy Davidson, what happened after the fact. But That doesn't particularly matter very much as well. Provides a bit of context on both ends of that. The cardboard's not really an issue here. All right, whether Mr. Jones was supposed to have it or whether he wasn't supposed to have it, that wasn't the issue. He was instructed to return to his cell. It was a lawful command. He was in jail. Your freedoms are a bit restricted in jail, of course they are. When you're told to go to a jail cell, you're supposed to be in your jail cell. It's for everybody's safety. It's for the officer's safety. It's for the other inmate's safety. The wrap at the end of this, it also provides a bit of context. Mr. Jones was not complying with commands initially to return to his cell, and then when he was put back under control with some physical restraint, he still refused to return back to his cell. Now, there's a lot of facts here. You heard a couple hours worth of testimony just about, but as I said, the thing that matters is he was told to be in his cell and he wasn't. Or Mr. Jones was told to return to his cell and he wasn't. By not returning to his cell, he called a number of deputies away from their other duties. They had to respond to him to put him back in his cell instead of supervising other people in the jail. All right. Your job today is to seek the truth. You've heard the testimony. You've heard from me and what I have to say, as the judge told you, is not evidence. But your job is to be a fair and impartial juror who honestly seeks the truth, not a vague and arbitrary doubt. You took an oath to listen and consider all of this evidence. All right, there's a couple different kinds of evidence. Most of what you have here today is direct evidence. That's evidence that is seen or heard, a testimony from a witness. All right, circumstantial evidence is also evidence that you can consider. There's not a whole lot of that here today, just pointing it out a little bit. It's evidence that you didn't hear about, but the circumstances require you to accept or encourage you to accept that that is what happened. As you're seeking the truth, you have to evaluate the credibility of the witnesses. You've had an opportunity to get to know the facts about the case. You have to weigh the testimony from the different witnesses, the probability or improbability of their testimony. So what they're saying is true. You can consider that along with the other evidence, including the video that you've seen here today. But as you weigh the other stuff, or as you weigh the witness's testimony, you're going to look into their interest in the outcome of the case. In this case, the officers are just doing their job. Mr. Jones, he's here today. He's facing some criminal charges. He's got some interest in the outcome of this case. You can weigh what the officers have as far as interests go yourselves. We don't really have any prior statements that y'all heard too much about other than what's on the video. And then we had a couple different witnesses. You heard one witness talk about what happened in the jail cell. You heard from Officer Young. That, as the judge is going to tell you, is going to be sufficient evidence.
It's like he's just trying to get this over with. Like, he's not really passionate or trying at all.
To possibly convict Mr. Jones, as long as you believe what the officer had to say. Why does all this matter, and why are you here? You're here to evaluate the evidence, and there's one standard you got to evaluate that evidence by, and that standard's beyond a reasonable doubt. And a reasonable doubt is just simply this: it's the doubt of a fair-minded, impartial juror honestly seeking the truth. You're not required to find guilt beyond all doubt, but you also should not require guilt to it, or proof of guilt to a mathematical certainty. At the end of this, I think you've seen the evidence, and I'm asking you just to agree with my evaluation of the evidence. I looked at the evidence, and I see that Mr. Jones did what the officer said he did. He didn't comply with their instructions. He hindered them in their duties, and that the commands they gave him were lawful. If you'd find the defendant guilty, thank you.
All right, members of the jury, as I told you, now is the time for me to give you the law that applies in this case. And also, as I told you, you're going to get it in writing, so you do not need to take any notes at this time. You are considering the case of the State of Georgia versus Jermaine Wesley Jones, case number 25 SR 2737. Whenever I refer to the defendant or the accused, I am referring to Mr. Jermaine Wesley Jones. The Solicitor General has accused the defendant with the offense of count 1, obstruction of an officer. In lieu of reading the...
Okay, that's good enough, right? We don't need to hear all the jury instructions. So count 1, obstruction of an officer. That's what he was charged with. The jury came back, but not on live stream. It's fine. I got everything. Don't worry. Jury came back, found him guilty. He got 11 months and 4 days more time. I don't know what that means in Georgia. Like, I don't know if any of that is good time. I don't know. But he got 11 months and 4 days, and he was fined $440. But the fine was suspended. So, he got probation. So he's going to get more probation after he gets out of jail. And I guess the fine is suspended as long as he does well in probation. I think like a charge like this, probation is stacked. And I don't know what his original case is. The furthest it goes back is to his case in 2024 when he obstructed an officer. That was a different obstruction case. And then in 2025, it looks like he had 2 obstruction cases, and this is the second one. So, of 2025. So, I think he has 3 obstruction cases total. I don't know what the first case was. And one of the reasons maybe I don't know is because I was looking in Hall County, and his first case might not have been in Hall County, even though he's incarcerated in Hall County. If he's obstructing, like if you mess with the guards in a prison, they can just take you and put you in another prison. And they do it all the time. And they also do it all the time just for resources. They move prisoners around. No warning to your families, nothing. They just move you. So, I don't know about his original case, but that's what he got for this one. Now, I think we're going to do another trial here starting tomorrow. That's not very long, but it's more than 1 live stream. It might be 2. But it's a pro se. But I just don't know if it's good enough yet. So I'm going to work today to see if it's good enough for you. Hi, Rose. And if it's good enough for you, then we're going to start that again tomorrow. We missed one part. I got to show you this one part. You'll like it. It was when he's talking to the judge at the end. Right before they drag him out. Okay, right here. We're going to play like 4 more minutes, maybe not even 4.
To take that verdict, you may now retire to the jury room, but do not begin your deliberations until you receive the accusation and these documents from the court. Any objection to the charge as read?
No.
No, Your Honor.
Okay.
No.
Yeah, I'll pull out the alternate. Okay. Let me have Juror 20, Ms. Kirkmeyer. Y'all can have a seat. Y'all look at the jury verdict and tell me if you're okay with it. I realized during the charge I hadn't done one, so I just did one. All right. All right, Pat, this is
Thank you, Jude.
This is the stuff that goes back. There's no evidence that goes back, right? Because everything was video. Okay. That doesn't go back, Pat.
Once the jury leaves, he's going to try to talk the judge out of everything. Real quick.
Okay. Ms. Kirkmeyer, you may have noticed and done some quick counting that there were 7 jurors on this panel. We deliberate with 6 jurors on misdemeanors in state court. So because you are the last juror selected just by your number, you are the alternate juror. And so that means you can't deliberate unless you're called upon, we need you, which happens and has happened recently to me. So what I'd like to do, if neither side has any objection, is just get your cell phone number and let you go about your life. And we'll call you if we need you. And then I'll call you and let you know when you're discharged, when it's done. Because once they have a verdict, you're free. But right now, you can't talk about the case with anyone, but you can go live your life. Yes. Yes, ma'am. You can go home or to the grocery store or wherever you need to go. Okay, so I'm going to get, Dr. White's going to take your number for me, and then I'll excuse you. Just don't talk about the case until you're discharged. Okay, very good.
Unrelated.
Yes.
Well, let's finish this up. Sorry.
Okay. All right, so the jury has it. So if y'all just want to hang close by, we'll be in recess on this unless there's something else from me.
Sure will.
Yes, sir.
Like I say, right here, it's in writing. They left me in the hole 11 months.
Okay.
They just moved me over there at 316, cell 421.
Okay.
Lord, my security. At the same time, it like...
Mr. Jones, the evidence is closed.
Yeah, I'm just saying, though, I want you to hit it.
But I mean, I'm not the one making the decision.
Yeah, but still, I still want you to just hit it. At the time, Officer Seabolt loosened the handcuffs, checking for proper fit, double locking, and I was wheeled into cell D2. D2 is up front in booking. I never went to a cell going in the dorm. They wrapped me up and they wheeled me up there up front. That wasn't me on the screen. They took 11 months to have a dude to go in there after looking at what hindrance is. They had somebody to play that out. That's what happened. And that wasn't me.
Okay. Well, I think you told that to the jury, Mr. Jones.
They had someone to play that out. That's not me, period.
Okay.
They telling you it's contradicting on here. They telling you they wheeled me up front.
Okay.
So you couldn't have took me up to no room. It's evident.
Okay. All right. Thank you, Mr. Jones. All right. We'll be in recess in the Jones matter until we have a question or a verdict.
That was the part I heard that the accent was so thick I didn't get every word there. I just didn't. But that wasn't me, is the gist. Okay. That was it. Now we're done. Now it's over. 11 months and 4 days and $440. Guys, thanks for coming out. Yes, I will see you tomorrow morning. Behave. Bye, guys. Thank you.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. So what